Good morning. Are you Corbin Rayleigh?
Yes, ma'am.
And Mr. Rojas, will your client waive the formal reading of the indictment?
He will, Your Honor.
Mr. Rayleigh, in cause number 25 DCCR 1482, you're charged with the state jail felony offense of engaging in organized criminal activity. And that's from September 28th of 2025. And how do you plead to that charge?
Yes, guilty, right? Sounds thing. Right.
So did you do this?
Did you do it or did you not do it? If you did it, it's guilty. If you didn't do it, then it's not guilty and we have a trial.
I committed a misdemeanor under that.
The underlying offense is a misdemeanor assault, Judge, because it was in combination with 3 people or more. He feels it should be a misdemeanor, but Mr. Coleman and Mr. Nichols wouldn't reduce it.
And you've talked to him about what engaging in organized criminal activity means. So you've gone over all of this with Mr. Rojas, right?
A little bit, yeah.
All right, I'm going to hold the case. Y'all go talk.
Yeah.
Ask any questions you have of Mr. Rojas. Listen carefully to his answers. He's telling you what the law is, and then we'll decide. You can decide if you want to take the deal or not, or if you want to go to trial. Cause number 25, DCCR 1482. How do you plead?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes, ma'am.
And are you pleading guilty because you did what they charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marks as exhibit number 1. Before you signed these, did you go over them with Mr. Rojas?
Yes, ma'am.
Do you fully understand them?
Yes, ma'am.
Do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
Yes, ma'am.
Now, it looks like the agreement that you've reached is for a 3-year deferred probation. There would be a $500 fine and you would be required to follow all of the rules and conditions of probation. Do you understand?
Yes, ma'am.
Do you also understand if you're not a U.S. citizen that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
State tenders number 1.
No objection.
It's admitted. Is there any evidence that Mr. Rayleigh is not competent?
No, Your Honor.
So, Mr. Rayleigh, your unwillingness today at first to take responsibility gives me some concern.
Yeah.
What you guys were doing that day was absolutely ridiculous.
Yes.
And somebody could have been seriously hurt.
Yes, ma'am.
A paintball can cause all kinds of serious bodily injury.
Yes, ma'am. And I told Mr. Rojas I'd be willing to do anything civil matter with the victim. You know, I'm not a just horrible person. No,
I mean, y'all, it was ridiculous and stupid. And you're lucky you're not here for an aggravated assault with a deadly weapon by shooting an eye or shooting somebody in the head in the wrong place.
Yes, ma'am. 3
people were shot just driving. You're lucky that y'all didn't get shot because somebody didn't think it was a real gun. And that's what people are doing everywhere now, is shooting people. So you're out there with a paintball gun, but you in turn could end up shot. So I just want to make sure you understand that giving me an opportunity to review this gives me some concern. You need to take advantage of this opportunity. You're very young. There's no reason for you not to be able to be successful and make some better decisions. But you need to understand the importance of this as felony court. Doesn't have anything to do with civil court.
Deferred probation might sound like an easy break, but it's anything but. Think of it as a final opportunity. Complete every condition successfully, and a conviction may be avoided. Slip up, though, and the court can move straight to sentencing. It's one of the biggest second chances the justice system offers, but it comes with serious strings attached.
Court and anything to do with paying them back. It has to do with you doing your probation right, and if you don't, you go to prison.
Good.
All right. So I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing just so I can get a little more information about you and your case, and then we'll come back later for sentencing. You need to stop and talk to probation on your way out of the courtroom today, and she's sitting at that desk right over there. All right? See you back at sentencing.
Yes, ma'am.
And that was for the second-degree felony offense in possession of a controlled substance. And then in October... Okay. September of 2017, same date, also put on a 5-year adjudicated probation for the state jail felony offense of possession of a controlled substance, cause number 172669. And so this is 17-26688. We were previously in court. Mr. Barlow entered pleas of true to counts 3, 5, 6, and 7. So we're just here in the second degree felony. The other one's already expired. I received an updated report. If you both had an opportunity to review that report.
Yeah, Judge.
Yes, Judge. Any additions or corrections?
Oh, not from the defense judge.
Not from the state judge, other than I think we have all previously discussed this before, that the new offense allegations all occurred in Harris County, and we waited some time for those to resolve themselves, which is why we're not proving.
Okay. And they haven't resolved themselves,
No, we're
or they
currently,
have.
no, we're currently set for trial next month. I want to say the 20th or 22nd of July.
Well, okay. So what he pled true to was failure to remain in Jefferson County, failure to report the arrest, positive urinalysis, and failure to pay fees. And everything else had to do. Let me double check. Yeah. Okay. So everything else has to do with, the cases over there.
Yes.
All right, Mr. Lewis, and there was no agreement. Mr. Lewis, you may proceed.
Well, Judge, since he's been on bond, he's been on house arrest. And I think that probably was one of the best things that happened to him, because it allowed him to, one, find stable employment, which he's been able to do. And recently been able to actually find a nice stable housing situation for him and his children. He's basically operating as a single parent, because his wife still legally his wife. She's in Harris County. He's here with the children. He's raising the children himself. So he's been able to find employment, find housing, and he's been doing this on his own. He's currently even. You got to see the bandages there. He had a situation where he had a burn incident, and he still was able to continue employment and continue working to take care of the children. So I know that the recommendations, of course, of probation have been either ISF or some type of zero tolerance of high risk caseload. We would ask that he will be placed on some type of high risk caseload where he will be able to continue that on, because I think any type of incarceration right now would be counterproductive with all the progress he's made over the last few months, Judge. And given his motivation, I think it'd be really good for him if we can continue that on, to especially taking care of those children.
Now the courtroom shifts from punishment to rehabilitation. Instead of focusing only on past mistakes, everyone, including probation, is discussing whether this defendant has actually changed. That's a question every judge has to answer. Is this progress real, or just temporary because court is watching?
Ms. Golfino?
Judge, I'd like to see if Mr. Kitchens has anything to add other than his report. I have a couple comments.
He has been doing, since he's been on a bond and in house arrest. I will agree with Mr. Lewis saying he's got a different attitude. He has been tested positive with the probation department, and it sounds like it's made a difference.
Okay.
And that's what I wanted to see, Judge, if you concurred with that. I would agree with Mr. Lewis that as many times as we've dealt with Mr. Barlow on this case, on other issues in the past, I mean, I felt like I've had him on my caseload for 5 or 6, 7 years. I don't know that derailing him now is beneficial. I know that the issues with this female friend or wife or whomever is obviously, you've got to get that straightened out.
I'm sorry to interrupt. What's the long-term?
Actually, when y'all put me on house arrest, that kind of like, it was hard for me to get away from because of my wife and my 2 kids. When y'all put me on house arrest, I've been on it for 6 months. So no contact. Only way I can contact through my mom. So the feeling that I had before is gone. Finally, y'all gave me a chance to get a job. I thank you for that. Got the job, worked as a regular worker. They just upgraded me to a supervisor. Been trying to pay 2 or 3 times a week, month. You know what I'm saying? I've been clean. I've been happy that I could take care of my kids and do things I couldn't do, which was real hard for me at the time because I was so focused on her. But through these 6 months, y'all kind of fixed me to a different position to see that I can do better without her.
So the long-term plan is not to try to reconcile and get back in that situation.
Like, it really just, it pushed me away because without this, I probably would have been still trying to be in a relationship with her, try to keep my family together. And Mr.
And
Lewis,
sometimes that's not the best thing for
yeah,
the kids.
Mr. Lewis had conversations with me as well on the side after coming from court in Houston and saying maybe this ain't what. You know, my dad haven't been there to tell me nothing. I've been dealing with Mr. Lewis about 8 years. And like I told him, he had told me a lot of father figure things that kind of dawned my brain that I couldn't even focus on without another male person that's in a good position in life to kind of direct me. So it kind of put me in the right stand. And Mr. Kitchens always was out to hear what I had to say. And I appreciate him as well.
Well, here's the thing, Mr. Barlow, if I give you this opportunity today, you've got to take advantage of it because you're not going to get this opportunity again. You've got everybody behind you. Mr. Lewis has worked very hard. I've signed, I don't know how many times he's sending over emails. Can he go do this? He's got a job. Can he? And I want you to do all those things that are positive, but you've got to stay on the positive track when things kind of lighten up a little bit eventually on probation. You're going to have to do it on your own. So what I'm going to do, I'm going to find that you entered your pleas of true to counts 3, 5, 6, and 7 freely and voluntarily. Find those counts true, find sufficient evidence to revoke your probation, but I'm not going to do that today. I'm going to continue you on probation. I am going to order that you're on the high risk specialized caseload and that it's zero tolerance. That means you just have to do it all right. You know, there's no hiccups anymore, no contacts, communication with Miss Foster. Continue doing what you need to about your kids through your mom. If that's working, then that's great. Use that. If that's not working, then there needs to be something else done. And I would think that to help you guys, it's once you get this taken care of, you need to save up what you can and get someone, you can talk to Mr. Lewis about helping you through the family court system so that y'all have some orders in place with regard to the kids. And there's not all of the communication that you might have to have now because things aren't set on who has what and doing what. But as far as I'm concerned, this is going to be your opportunity. No contact. I mean, I'm not going to leave you on house arrest anymore. I want you to go work and do those things. You cannot leave Jefferson County. If she comes to Jefferson County, you better avoid her. If she shows up, you better go lock yourself in a closet. And
Notice how specific these instructions are. No contact means exactly that. Even if the other person reaches out first, violating the judge's order can still land the defendant in prison. Court orders aren't suggestions. They're legal obligations, and responsibility stays with the person under supervision.
Call the police and say, I'm trying. She's bothering me. She can't give you permission to violate my order. Okay, so she can't say, it's okay, let's just talk about the kids. It's not okay because you're going to end up in prison, not her. Does that make sense?
Yes, ma'am.
All right, so I'm handing you the trial court certification. This wasn't an agreement. You can talk to Mr. Lewis about that. And if there's anything else, Mr. Kitchens, that comes up that you think would be a good condition to add that would help Mr. Barlow, then just let me know. We'll make that happen. Good luck to you. Thanks. She's nice when they listen. And good morning. Are you Broderick Guillory?
Yes, ma'am.
And will your client waive the formal reading of the indictment?
He does.
Mr. Guillory, in cause number 25 DCCR 1716, you're charged with the state jail felony offense of burglary of a building from February 3rd of 2024. How do you plead to that charge? Are you pleading guilty freely and voluntarily? And are you pleading guilty because you actually did what they've charged you with?
Yes, ma'am.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Lewis? Do you fully understand them?
Yes,
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal? And it looks like that agreement that you've reached is for a 3-year deferred probation. There will be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding?
Yes.
You also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law. State Tender's number one.
No objection, you.
It's admitted. Is there any evidence that Mr. Guillory is not competent? All right, so I'm going to find that you entered your plea of guilty freely and voluntarily. Find that you're mentally competent and you understand the nature and the consequences of your plea. Ms.
I'm looking,
Malvina?
Judge, it looks like what they alleged is not the right word, but what they stated was that the appliances were approximately $1,000 each and the window to be repaired $600. That being said, that's in the offense material. They have failed to, since 2025, submit a restitution request at our letter request. I don't have a problem waiving the PSI if you want to do maybe an amount not to exceed, but that's all the information I have. I will send another letter.
I think since restitution is a possibility, I'm going to go ahead and get the pre-sentence report done. That way they can also reach out potentially if there's any amounts that get confirmed between now and then, we'll do sentencing then. So again, find sufficient evidence to find you guilty. But what I'm going to do is reset the case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case. More specifically, really about the restitution that could potentially be ordered. So if there's restitution, if there was something that did not get returned or things that were damaged, then that is going to be part of your probation that you pay that back. And so we're going to go through this process so that they can see if they can get those amounts. When you're leaving today, you need to stop and talk to probation. She's sitting at that desk right over there, and then we'll see you back at sentencing in a few weeks. All right. Thanks. You're free to go. Good morning, sir. Are you Rodney Hines?
Yes, ma'am.
And Mr. Hines, did you get someone hired?
No, ma'am. I talked to a few lawyers, because of my background, they want a significant amount of money.
Who'd you talk to?
Talked to, Brittany Holmes, Ryan Gertz, Corey Grishaw, talked to right from secretary. I'll probably go meet her when I leave. They just wanted to have money down because of my background. But they will get out.
And where are you working?
I got it's working at the port. I got another interview at AWP, safe when I leave.
So you're not working at the port right now?
No.
Why not?
But they was at a job in Corpus and I couldn't go a couple of months.
I'm going to, if I test you this morning, you gonna have anything in your system? Let's double check that and then we'll talk about your options. Have a seat in the jury box. And Mr. Hines, you tested positive for THC. When's the last time you used marijuana?
3 weeks ago.
So you're trying to get a job, you have jobs, and you know you're gonna get tested on jobs, especially the type of job that you're doing, and you're using marijuana.
You know, I ever since last call, I've been trying to get clean. I had stopped smoking. Since I got the job offer from multiple job offers, I had stopped smoking. See, right now I just do has a little work for cleaning up trucks with CDL. I'm also in class and try to get my CDL. So that's what I've been getting my little money from.
So here's what you're gonna do, Mr. Hines. You're gonna get a drug patch. You're gonna get it on today. You can ask your bondsman where to get that. You're gonna wear your drug patch. Obviously, it's gonna test positive, probably the first go round, but if you're telling me the truth about 3 weeks, then it should be going down and be negative within the next patch. You have to get them changed every 2 weeks. If you do not get it changed on time, if you show up and it's not testable, it falls off, anything like that is going to be a violation of your bond, and you will have your bond raised and you will be back in custody. No questions about it. Do you understand? So you need to talk to your bondsman. And actually, if you, on your way out, there's probation right there. She has a list of places where you can get that as well. So you can stop and ask her for that list. I need proof to your bondsman today that you have a drug patch on your arm. Okay? All right, step in front of the clerk. She'll give you a resit notice.
Yes.
The indictment.
I'm on your side.
And are we going on just count one? Well, we won't. Yeah,
Yeah,
No.
just count one with the priors for the district.
right. Okay, give me a second. Okay. In there. All right, Mr. Williams, in cause number 24, DCCR 2242, the state's elected to proceed on count one only. It alleges that you committed the third-degree felony offense of driving while intoxicated, March 31st of 2024. The indictment further alleges that you were previously convicted of driving while intoxicated, March 28th of 2014, and also May 2nd of 2022. And how do you plead to that charge?
Yes,
Are you pleading guilty freely and voluntarily?
yes,
And because you did what they charged you with?
yes,
And are those two prior convictions for DWI true?
yes,
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Mr. Johnson?
yes,
Do you fully understand them?
yes,
And do you understand if I follow the agreement that you've made with the district attorney that you'll be waiving or giving up any right to appeal?
One final legal detail that's easy to miss. This isn't the sentencing hearing. After accepting the guilty plea, the judge orders a pre-sentence investigation. That report gives the court a much fuller picture of the defendant's background, employment, criminal history, and risk factors before deciding the final sentence. It's a reminder that a guilty plea is often the beginning of the sentencing process, not the end.
And it looks like the agreement that you've reached is for a 10-year term in prison, but that will be probated. You'd be on probation for 8 years. You would be ordered to pay a $1,000 fine and to follow all of the rules and conditions of probation, and that would include those 10 days upfront time. Do you understand?
yes,
Do you also understand, sir, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
yes.
State tenders number 1.
Objection, Your Honor.
It's admitted. Is there any evidence that Mr. Williams is not competent?
No, Your Honor.
All right, sir, I'm going to find that you entered your plea of guilty freely and voluntarily, find that you're mentally competent and you understand the nature and the consequences of your plea, find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give me more information about you and your case, and then we'll come back at a later date for sentencing. On your way out of the courtroom today, you need to stop and talk to probation, and she's at that desk right behind you.
Okay.
All right, we'll see you back at sentencing. Thank you.
Thank you, Your Honor.